Good afternoon and welcome to this week's webinar presented by the firm of Beresford Booth. My name is Per Oscarsson. I'm a member of the estate planning and probate group here at the firm. My topic this week is what are ademptions and advancements in probate? These are two concepts that apply. One will apply only when a will is involved, and that's the concept of ademptions. Advancements can apply whether or not there is a will involved. Well, let's start with ademption. An ademption can occur when there is a specific bequest of property that ends up being revoked by the maker of the will if they don't, effectively revoked, if they don't own the property at the time of their death. And there are two ways that can happen. One is ademption by extinction. The other is ademption by satisfaction. So ademption by extinction means that the property just is no longer owned by the maker of the will. And that can happen because after the maker of the will signed their will, maybe they sold the property. Maybe it was destroyed in some way, or they may have transferred it to someone other than the named beneficiary in the will. And that could happen, for example, it could have been made a gift to someone, or maybe they were doing some other planning and they, for asset protection purposes, for example, they may have transferred it into a limited liability company that they own, but they no longer own the property, because once the property is put into a limited liability company or an LLC, the LLC owns it. Even though the maker of the will may own the LLC, they don't own the property that's owned by the LLC. The other possibility is an ademption by satisfaction. And in this case, the property that was named in the will has actually been transferred to the beneficiary named in the will, as opposed to being transferred to some third party. And it could have been transferred, it could have been sold to the beneficiary, it could have been gifted to the beneficiary during the lifetime of the maker of the will. So here's a couple of examples. The two easiest are the car, or a car, and real estate. If there's a specific piece of real estate or a specific car that's involved, the only way to redeem is if that particular item actually goes out of the estate. And it could go to the beneficiary who's named in the will. And it has to be a specific bequest. The less clear example is when there is a specific bequest of money from a specific source. Then it becomes a question of, is this a specific bequest or is it a general bequest? If it's a specific bequest, that particular item has to be transferred under the will. If it's a general bequest, and money could fall into either category, if it's a general bequest, then the concept of ademption does not apply. And if it's the issue then becomes, what was the intent of the will maker? The thing with money from a specific source, they may say, one of the cases deals with a widow who had said, well, the $3,000 from the life insurance policy that my husband had. Well, is it that specific $3,000 that's involved in that bequest, or is it just a bequest of $3,000 generally? And then in which case, maybe the source of that $3,000 does not matter. That's something that the court will be looking at, because they need to determine what was the intent of the maker of the will. Was it that specific source, or was it just the fact that that happened to be the source for the $3,000 that's involved? In that case that I mentioned, which was a case from many decades ago, The court determined that it was a general bequest, and some of the money was even gone because in fact, most of the money was gone because the widow had used some of that for her living expenses. And the court determined that it was a general bequest of $3,000, not required to be satisfied out of the money that had been actually received as proceeds of the life insurance policy. There is an exception under the statute, and that has to do with if a will provides for a distribution of a specific bequest of a distribution of property, and then the owner of the property, the maker of the will, enters into an agreement to convey the property, that agreement does not in and of itself revoke the device or the bequest in the will. The property passes by the device or the bequest, device or bequest, depending upon whether it's real estate or some personal property. It passes by the device or the bequest, but it's subject to the same remedies on the agreement that the buyer would have that would have been available by law against the heirs of the maker of the will if the person, the maker, or if the deceased had died without a will. And I have a little example here. So assume that the will maker bequeaths the house to person A. They then enter into a contract to sell the house to person B. The proceeds of sale are in escrow when the will maker dies. And this was an actual Washington case. In this case, person B, the one who entered into the contract to buy the house, received the house. Person A, who was bequeathed the house, actually received the net proceeds from the sale of the house. Now, as some commentators have mentioned, if the closing on the house had occurred before the will maker died, so there wasn't any escrow in place at the time the will maker died, person B still would have received the house because they received it during the will maker's life. But person A, who was supposed to receive the house under the will, does not even receive the proceeds. So the entire bequest to person A effectively disappears. There's another exception in Washington. Other states have ruled differently. The doctrine does not apply. The doctrine of Ademption does not apply if the property that's included in the will was disposed of before the maker executed or signed their will. I have an example here. The will maker sells their car, and 6 months later, they sign a will that bequeaths their car to their son. In Washington, that is not considered an Ademption because the Ademption has to occur after the will has been signed. In some states, the doctrine has been applied in a situation similar to my example, but it was usually applied in the few cases that I have discovered to address the situation where they thought the will maker made a mistake at the time they signed or executed their will. In one case, the will maker had stock in one insurance company, and they then sold that stock and acquired stock in a second insurance company. When they subsequently did their will, they bequeathed the stock of the first company to one person and the stock of the second insurance company to a second person. The problem was they no longer had the stock in the first company, but they did have the stock in the second company. In that case, the court decided that the person who was bequeathed the stock in the first company did not receive anything. The person who received the stock in the second company, again, that stock in the second company had been purchased before the will was signed. That person did receive the stock of the second insurance company. The other concept I wanted to touch on was advancements. And this is a concept that can apply where a will is involved or where there is no will involved. And the issue is whether a gift that was given by the deceased person during their lifetime was intended as an advance against what the will beneficiary or the heir would have received upon the deceased person's death. So the will can specifically provide that a gift made to the beneficiary during the will maker's lifetime is to be in advance. And if the will provides that the recipient of the gift receives, as an example, 30% of the estate, then if it is an advance, then the value of the advance is deducted from the 30% of the estate, so that when you include the advance plus what the person receives under the will, now they have received a total of 30%, but it's not 30% of the estate that exists at the time that the will maker died. Now, very often, a will may be completely silent on this issue, and there may have been gifts given over the course of the lifetime of the maker of the will, or they may have been made very recently prior to the deceased's death. Now the question becomes, what was the will maker's intent? Again, the court will look at the will to see if there's any kind of indication of what was intended. I think typically, if the will is silent, unless there's some other good evidence that the will maker had intended that any gift given during their lifetime was intended as an advance, the court would certainly take that into consideration. But I don't think it's a guarantee. The doctrine of redemption by satisfaction may also come into play. Person A was deeded, or was not deeded, I'm sorry, but was bequeathed a car. During the lifetime of the deceased, they gifted that car to the beneficiary named in the will. Now we've got the doctrine of redemption because we have a specific bequest of the car, and it no longer exists in the estate as the date of death of the individual. But then again, we have the question of, well, was the gift then intended as an advance against the share that the will beneficiary of 30% was intended to receive, or is it not in advance, and therefore not treated as a credit, if you will, against the share that they receive in the estate? If there's no will involved, then the Washington statutes on descent and distribution, that's set forth in RCW chapter 11.04, that will apply. Those statutes generally will tell by relationship to the deceased what fraction of the estate of the deceased a beneficiary or an heir would receive. Where there is community property and separate property, it will differ. If there is community property, all of the community property will go to a surviving spouse, if there is one. If it's separate property, then it will depend upon the relationship of the heirs to the deceased. Typically, where there are children involved, the surviving spouse would receive 50% of any separate property, and the children, if more than one, would share the other 50%. If there are no children, then the surviving spouse would receive 75% of the separate property, and the other heirs would share in 25%. There are a number of other considerations that go into determining who is an heir and who would receive how much that way. But that's beyond the scope of this webinar. One section of chapter 11.04 provides that if a person dies without a will, a gift that was given, quote, as an advancement, close quote, during the deceased's lifetime to an heir of that person will be counted against that heir's share of the deceased person's estate. That makes it a little bit different from when there is a will involved, because here we have the presumption that if it was given as an advancement, it shall be counted against the heir's share of the intestate estate. But the statute also provides that if the gift was given during the deceased lifetime, it's deemed to be an absolute gift unless it was shown to be an advancement. So if it was deemed to be an absolute gift, then it would not affect the share of the estate that the heir would receive as a result of the deceased person's death. And with that, I come to the conclusion of this webinar. I thank you for watching. Our firm's next webinar will be from our family law group and assisted reproductive technology group. Again, I thank you for watching. Have a great day. Goodbye.